Hello. In this module 2, we'll be studying legal procedure for mergers and acquisitions. So, while studying legal procedure for mergers and acquisitions, we should understand that mergers and acquisitions need to be carried out according to the Indian Companies Act 2013. And not only this, but other acts and rules and regulations and notifications from relevant authorities need to be adhered to. Those are regularly updated, so we also need to update ourselves. So apart from the Indian Companies Act of 2013, what else we need to follow is like Indian Contracts Act, and as amended, of course, because it's amended from time to time, so the latest act, and this governs contracts and the rights that the parties can agree to enter into a contract or agree contractually under Indian laws. Now, then there is Specific Relief Act. Now, Specific Relief Act and that is also has amended from time to time, so the latest we need to follow. This prescribes remedies available to private parties for breach of contract. So, we need to adhere to this act as well. And then the Income Tax Act. This prescribes taxation-related considerations under mergers and acquisitions in India. So it's the Income Tax Act 1961 as amended from time to time. And it also covers transactions that have cross-border elements as well. Because sometimes there are cross-border mergers and sometimes there are, of course, local mergers, but there are some considerations of investments or sales pertaining to other countries, and some compliances might not have met, or the compliances are going on or not, and to what degree this needs to be considered as well. Then there is Indian Competition Act, because there might be some situations where some companies breaching the Competition Act, and the relevant authority that has been created under the Indian Competition Act is the CCI, that is Competitions Commission of India. So this commission looks into competition. We can discuss a relevant case in this scenario like Google. Google gets into our mobile phones when we use Android. Now they plan their own apps like Google Drive and YouTube and all. So those are inbuilt, those are with Android, and we cannot even delete them. So it is not allowing a healthy competition to its competitors. So in this case, someone filed a complaint with the CCI or the Competition Commission of India, and it imposed a penalty of, I guess it was $1 billion on Google. Now Google filed an appeal with some High Court or Supreme Court. So now it has challenged the order of the Competition Commission of India and is saying that it might have to leave India or quit this Android in India or whatsoever. So now it has violated this code. Now suppose if Google seeks to merge with some other company, so that other company must address this case as well. It should also understand that there are some penalties on Google and it's not compliant with the competition code. So these things also need to be kept into mind. Otherwise, these things come under due diligence. And if these things are not kept into mind, then later losses may occur. And there may be differences amongst the members or the relevant parties. And some people may say they were not aware of this penalty or some undue practices or illegal practices or unjustifiable practices, because some people are more into goodwill. So in this case. So then there is FEMA, that is Foreign Exchange Management Act. And there are rules and regulations based accordingly. And there might be some court rulings issued under this foreign exchange management. So we need to adhere to all of them. So you need to read it. When we say the FEMA, we need to read it along with circulars, directions, rules by the RBI, which collectively regulate for foreign investment in India. So in case of cross-border mergers and acquisitions, then there is Consolidated Foreign Direct Investment Policy Circular of 2022, and it also keeps on amending. There might be some amendments. So we need to read it together with the press notes issued by the DPIIT, that is Department of Promotion of Industry and Internal Trade, and that comes under the Ministry of Ministry of Commerce and Industry of the Government of India. Then there is SEBI, or the Securities and Exchange Board of India. Now, this is pertaining to the listed companies. Those have issued their shares in public. So Securities and Exchange Board is connected to that, and where the shares are available in stock exchanges. So SEBI guidelines or directions or notifications or circulars whatsoever need to be adhered to. Now, there are labor legislations laid down by the central government as well as the state government according to the company location, maybe according to the registered address or the corporate address. Not only this, also at the addresses of transaction or the transaction of business, because wherever the employees are working, the codes of that location need to be followed. So in this case, we need to we need to see the compliances according to the legislations laid down by the central government as well as the state government, as the case may be. After understanding that, what else we need to be kept in mind, and we studied various laws and notifications from authorities and guidelines or whatsoever. Now, we've understood at least a framework that not only the Indian Companies Act, but some other factors or other laws and regulations also need to be kept in mind. And those are regularly updated, so we need to keep ourselves updated all the time. We need to live in the real time. Okay, so this was about it. Now what are the conditions preceding merger or acquisition? So conditions, those are required to be met before a merger or acquisition is brought about. So there needs to be corporate authorization. So corporate authorization is, this authorization is done by the board of directors. They have permission from the shareholders. So after this corporate authorization, due diligence needs to be done. And due diligence is done by all the parties or all the companies those are involved in this merger or acquisition, because they need to understand each other. They need to gather information and then understand that everything is going on in a proper manner. Then they also need to take NOC from lenders or creditors. Without NOC, they cannot carry out, otherwise there will be lawsuits and the merger will go haywire and it will not be able to brought about. And then regulatory approvals need to be taken, and wherever required, foreign investment permissions are also needed. Now after that, what is the legal procedure for merger? Under legal procedure of merger, the first thing that is done is examining the object clause of the Memorandum of Association. The association formed results into a company. So the Memorandum of Association needs to be established, which contains object clause, because we need to see that the merger or acquisition is in compliance of this object clause. If object clause provides, then a merger or acquisition can be done, and how it can be done or what conditions are required to be met, the object clause contains. In case it is silent, then they can go ahead. If it is not silent, but on whatever cases it is not silent, whatever conditions are mentioned and are in accordance with the law, of course, and obviously, those need to be met. And then the requirement is intimation to the stock exchange or SEBI in case of listed companies, and some other authorities as well, whosoever is concerned according to the company, because many companies operate in different domains. So there are different authorities concerned with that. So they need to inform those authorities as well. Especially like these notices need to be issued to the Department of Business Affairs. That is usually regional director or registrar of companies or official liquidator. And RBI also, and maybe Competition Commission of India, and also stock exchanges, because in case of listed companies, they need to inform the stock exchange as well. Now, after this, approval of merger proposal by directors board. Now there are board of directors of all the companies under the merger and under the acquisitions. These companies need to affirm, the directors on board obviously need to affirm on the draft of the merger and pass the resolution by voting for approving its key administrative staff and relevant administrators to pursue the issue. Now it comes into motion. Unlike the 1956 Act, the 2013 Act allows shareholders and lenders an opportunity to vote by post as well. Earlier, the voting was done in person or might be through a proxy, but the proxy would also need to go there in person, but now it can be just done through post as well. Now, then NCLT permission is required. With the introduction of NCLT, the process of mergers and acquisitions has become more tough and time-consuming. Now we see here what has happened. The jurisdiction of High Court was applicable, so lawyers were more concerned. Now with the introduction of NCLT, CAs try to become more concerned with the process of mergers and acquisitions. And this also transfers powers or transfers impact of judiciary to the executive. We can say that NCLT, we may say NCLT is a quasi-judicial organization or an entity, but it's not perfectly judicial after all. So under this case, we see that the power has shifted from the judiciary to the executive, because those are more concerned with executives, because government has control over everything. So this is an understanding that we can understand for our personal knowledge. So this is the thing. Now, exceptionally fast-track mergers are possible in case of mergers between certain categories of companies. So NCLT is not intervening in all the matters, but there are some exceptions as well. Like there are mergers between small companies, or mergers or acquisitions between some startups, or between a holding company and its own subsidiary company. Okay, under these circumstances, because that holding company itself is holding the subsidiary. So because it itself is holding its own subsidiary, so there are certain exceptions where mergers can be undertaken outside the NCLT process, but with the approval of the central government. So this we need to keep in mind. That now we need to apply to the court. Now, which court? Now the court, of course, here is NCLT. After getting affirmation on proposal by the board of directors, the merger organization should file an application to the court for the merger, of course. Now, notices to shareholders and creditors. Now, with the court's approval, a notification needs to be sent to all the investors, creditors of the company about the meeting to be held, and 21 days of timely notification is required. The notice should be distributed in 2 papers, one in the vernacular language of the state and other in English. So the other version is English version. So English is always there. Now, then filing of the orders with the registrar of companies. Now, a certified copy of the request of the court must be documented with the registrar of companies within the limit time period as indicated by the court. Or these might be updated from time to time. So we need to check in the real time under what time frame we need to submit this. Now, assets and liabilities of both companies should be merged. We need to keep in mind that both assets as well as the liabilities of the company should merge. So the company should not hold back something under private arrangements. So after this process is complete, the companies can now issue its shares or debentures in its new form or the newly formed form. Because after merger or after acquisition, it's like a new company. The new company that is now persisting. So in its new capacity, it will be able to issue shares or debentures. As we know shares, we know debentures. Debentures are debt instruments, and those are also floated in public, and we need to take certain permissions regarding that. So after it is formed in its new way, or the newly formed entity or the company can now issue shares and debentures. This means that now the process of merger or acquisition is complete, and after this completion, in its very new form, it can issue shares and debentures, and it can transact all the businesses rather. Now we have learned legal procedure for mergers and acquisitions. Now a detailed description how to bring up about this merger is given in the student's manual.